Two-part question, which, taking a look, and we all accept the studies that were done regarding anti-Semitism and the role it played. The questions I have are as follows. First, what do you think the economic collapse of Germany played? I guess it was the collapse of the Weimar Republic, and also the massive dislocation of people that did take place at the end of World War I. And looking at those two factors, what role do you think they played in providing the breeding ground for the anti-Semitism, and then equate that to the economic issues and dislocations of people today?
I assume that's for me. Let me say, first of all, it's a very good question. It's right on target. There's no doubt that, in my mind, I think most historians would agree that Hitler would never have come to power except for the economic crisis of the late 20s and 30s, early 30s. And there are two pieces of that. The first and very, very important piece that's usually underappreciated is the reparations. Remember, the treaty that was signed at the end of World War I required Germany to pay for the war. And it was a peculiar arrangement that the victors took revenge on Germany. But what's not understood is that it's almost certainly the case that the German government, realizing that they had to pay back the debt in Deutschmarks, consciously devalued the Deutschmark to the point where it was worthless. And by the late 1920s, people used to get paid twice a day in Berlin because what you got for your morning's wages you wanted to spend at lunchtime, because by 5 o'clock it would be even less valuable than it was at 12 o'clock. Now, when you have that kind of hyperinflation, it completely destroys the stability of the social order, because people who own property see it devalued. People who have savings, the savings essentially disappear into nothing. People have insurance policies, retirement policies, savings for their children. So the hyperinflation is crucial. And then it's compounded by the economic crisis of the Depression. And if you map the vote for the Nazi Party in the early 30s, you see something interesting. In the few months where you get economic improvement, the vote goes down. In the months where the economic improvement collapses, the vote goes up. So that question is right on target, and the answer is yes, yes, yes. You couldn't have had Hitler without the economic crisis. And that, of course, is why the German government, since World War II, has been so conscious about economic performance, making sure they have a strong economy as the best way to buttress the government against future shocks like the shock of Nazism. The second question is also a good question, and it's because what happened was, at the end of World War I, people have to understand, World War I was for us, it's sort of history, we don't know it. But we should remember it was a world-changing event on a very, very grand scale. 4 empires disappeared. The Tsarist Empire disappeared into Communist Empire. The Kaiserreich disappeared in Germany. More importantly, the Austro-Hungarian Empire collapsed, so all the countries of Middle Europe were in flux, and the Ottoman Empire took the wrong side in World War I and collapsed. The result was that after World War I, about 80% of the Jews of Europe were in countries that didn't exist before World War I, and including a very large percentage of what were called Ostjude, Jews from Eastern Europe who had come west. When the Ostjude came west, that created a special sort of tension, because the Ostjude, unlike the Jews of Vienna or Berlin or Amsterdam, Paris by the 1920s, who had become very acculturated, assimilated, spoke the local language, wore the same clothes. The Ostjude didn't speak the languages, they spoke Yiddish. Many were still religious. They dressed in traditional garb, so they're identifiably different. And if you remember Mein Kampf, Hitler says, I was walking the streets of Vienna, and there I saw him, and that was a Jew. And he meant, of course, an Ostjude dressed in a kaftan and a traditional. And they said, now I understand why I have to be a scientific, his words, a scientific anti-Semite. So the Ostjude is also very important. Those are two very fundamental conditions for the rise of Nazism.
Any other comments on that? Do we have another question? in countries where the Constitution is sacrosanct, like the United States. The 13th Amendment, which abolished slavery, still permits slavery if you're in servitude. If you are if you were convicted of a crime. I've always found that problematic. I think the history of civil rights in America can attest to that. How do you tackle issues like that when, the United States is obviously viewed as this beacon of freedom and liberty, when, as lawyers, you have to be within the confines of that Constitution. Due process questions, with prosecuting drug offenses, things like that. How those might be, I guess, obviously smaller issues than the scale of things in Nazi Germany, but as we've discussed, it was kind of a trickle system, throughout years of these laws that were passed. So in these advanced democracies like the United States, other countries, what's the best recourse for attorneys to actually, tackle these smaller issues that then could become harder for us to tackle in the future?
I'm going to pass this on to John to talk about it from his position as an Attorney General. But I also note, and one of the things that's often forgotten in the United States is, yes, we have a constitution, but we have 50 constitutions. So one fruitful place for lawyers in combating issues of civil rights abuses and other things is not only to look at the federal constitution, but to look at the state constitutions. All you have to do is look at the experience in New Jersey and our Supreme Court over the last 50, 60 years, utilizing parts of the New Jersey state constitution to deal with some of the issues that could not be addressed or were not addressed by the U.S. Supreme Court, given political times. And I think, so we all forget as lawyers that there are other areas of the law and Constitution that we can use in our practices in defending the rights of individuals, in trying to address some of these issues.
That's what I was going to say. But just to add to that a little bit, I teach state constitutional law, and one of the things that I impart to the students is, it's malpractice to forget about the state constitution, particularly in the era that we're in, where state constitutions are generally held to provide more protections of individual liberties than the federal constitution. But I guess the larger point is that the virtue of a constitutional system, a system based on the rule of law, is that it has provisions for self-correction, and it can change. When you have a system based on the rule of a person, you don't have that flexibility, and you don't have the ability of a society to correct its mistakes. And I think that's the virtue of our particular form of government and why the Constitution is so important.
I'd like to supplement by making a direct comment to the attorneys who are here from Ukraine. I had the opportunity to be in Ukraine, in Kyiv, on a criminal matter, a year and a half ago. Someone was under investigation, and I decided to go directly to the Office of General Prosecutor in order to find out what was the information about the investigation that they had ongoing, so that the defendant could be fully informed of the charges against him. The General Prosecutor's Office said they wouldn't see me or the Ukrainian lawyers that we were working with. We decided, therefore, we had a choice: do nothing or press forward. We showed up at the office of the General Prosecutor at exactly the hour when we had requested the appointment. They said we couldn't be seen. We said we're not leaving until we can be seen. We then called the press and we held a press conference right there and said, underneath the sign of the general prosecutor, and said, we're requesting information on a case. Not secret information, but information that should be made available to someone identified as a defendant. To make a long story short, after an hour and a half, we refused to leave. They sent us the chief investigator. We had a 2-hour meeting. They gave us some information. They didn't give us other information. But here is my point. Whether it's in the courts in New Jersey, civilly run criminal courts, if you understand my point, or whether it's in the courts in Ukraine, which is run by the government with a strong fist, you as lawyers have both an opportunity and a responsibility to press the law for your client. That means truth, access, information, and a demand for justice. Each of these little things that you referred to in your question, maybe, this one's not so big, this one's not so important, add 2 and 4 and 8, all of these different incidents together across a city, across a country, and it becomes mammoth. The only thing that stops it is vigilance with each and every situation. That means doing your best. And if there aren't resources in the United States, we have the Public Defender's Office, or in civil cases, we have legal aid. I'm not sure what you have in Ukraine, but it's up to the Bar Association and the lawyers to demand systems that preserve and protect justice for every single individual. The question referred to the Constitution. The Constitution presumes the U.S. Constitution presumes each person innocent until proven guilty. And the standard of proof of guilt is beyond a reasonable doubt as to every single element of the crime. Therefore, when you return to Ukraine, demand justice for each and every single thing and force the government to prove every element of the case. And if they can't prove every element of the case should be dismissed. Better that somebody guilty go free than a free and innocent person be punished.
Another question in the back?
Thanks for your answers and your inputs this morning. I'm a layman Brit who happens to support Brexit. And the first point I want to make before I ask the question is thank you. For me, you've made your profession appear to me significant, important, and even exciting. And even the Honourable Mr. Katz, who's not a lawyer, but it's been such an interesting time this morning. So, my question is this, and I think it's been unravelling as we go on. Britain is now attempting to come out of the EU. What do you do when you've got a number of nations with all different laws? How do you respond? Obviously, the time of the 1930s was very important, what was going on then, but what was happening in other nations, and what is international law? How does that work, if there is such a thing? Got ya!
I don't know if the translators can work with this word. I thought that was a rhetorical question. No, it's a challenge, and part of it is a reflection of what we're doing here today, in the sense that how does international law work? Pre World War II, you had the League of Nations, you had the collapse of the League of Nations. I happen to be my grandfather worked at the UN. My great uncle helped establish the World Bank. How do you do it? You reach across. You have visitors from the Ukraine. You reach across to Brits who even support Brexit, and you have the discussions. And it's, I would say in terms of the profession, it's our obligation, and I would say our ethical obligation, to continue to those conversations. We've talked among us earlier today about taking this program or parts of this program out, for example, to other states in the United States, to take it to Canada, to take it to other places. How does international law work? And something Richard said, he was acting in his role as a lawyer, getting the press there in front of the prosecutor's office. I would say that that's not so much being a lawyer at that point, that's an act of civil disobedience, and that also plays a role in this.
But I think we should also put it in the context of what arose out of the Nuremberg trials. A whole body of international law and international human rights law that didn't exist before the trials. I want to encourage you to take a look, and we'll post the link for everyone, to the volume from the March of the Living symposium that was done 2 years ago on the Nuremberg laws and the Nuremberg trials that also features Professor John Barrett, who you're going to hear from next. We did a whole day's symposium like today. We then transcribed it. We had outstanding experts, including Erwin Kotler, Alan Dershowitz, justices from Supreme Court, from Rwanda and Israel and Canada, and others. And we transcribed it, very old style, as well as having video. We posted the video so the whole world could see it, and we'll send you the links. But then we transcribed it, as I said, and working with Loyola Law School in California, they produced what's called the Nuremberg Symposium special edition of their law review. It's this thick, it's available. It's also available free online. We'll send you those downloads, and it will give you information on the development over the last 50 years of international human rights law. To your question about Brexit, there's a legal position right now that I know the lawyers are looking at, and that is the Great Britain, this moment, still in the EU, still under the court system, still under the foreign ministry system, shall we say, a foreign relations system? The answer is yes. You haven't yet exited. Therefore, the lawyers have the opportunity to do creative arguing, to apply UK law, but also EU law. EU law means the ability also to run over to the European Court of Human Rights, following all the necessary procedures. I can tell you, even in cases involving Ukraine, the threat of going to the European Court of Human Rights, the threat of going to the Council of Europe, the threat of getting support from the NATO countries because of the special status of Ukraine, gives you power, because then you can also get the attention of legislators, members of Congress in the United States. You can get the support from the Ukraine of lawyers in the United States who are interested in all of the region of the former Soviet Union. So the fact that you're here, I hope, proves to you you're not alone, but make sure you understand there are many resources out there to support you. And on Brexit, it's the same thing. You'll decide, the government will decide whatever it decides. But for people who need protection, you can really argue twice, and we'd always rather have a second shot when we can get it.
I think I want to thank the speakers this morning. I think it was excellent, provocative. I hope that you've left here with more questions, actually, than answers, because the most important thing about all of this is continuing the discussion, continuing the conversation, reflecting on our obligations, our ethical obligations as lawyers, be it in Great Britain, in Ukraine, in the United States, as we continue to confront issues on behalf of innocents, on behalf of our clients, and as we confront the possibility of laws being passed that are damaging and have the way that we can lead down. We are going to stop, and I think, John, you're going to turn it over to Professor Barrett, and thank you.